Good afternoon and welcome to episode 8 of the It's Law podcast. Today I'm Richie Edwards. I'm here with Troy Froderman, and today we're going to talk about why courts in Arizona take so darn long. We've titled it, in our notes and our discussions, Justice Delayed. Troy, it's shocking to people when we tell them you're coming to us today, September 2023. You're not getting into court in 2024 unless you're extremely lucky, and it could be halfway through 2025. Tell us about how it used to be, and we'll get into how it is now and maybe a little bit of why.
Yes. So I was mentioning to you before we got started, when I started in 1989, technology in the legal arena stunk, but our docket moved fast.
Yeah.
Now our technology, especially in Maricopa County, it's state of the art.
Yeah.
But our docket is clogged. So there are a variety of factors for that. When I first started, there were just 12,000 lawyers licensed in Arizona.
Yeah.
Now we have close to 40,000. And that's just people who are licensed. That's not including paralegals.
Right. Yeah.
So I don't know how many judges we had back then, but today in Maricopa County, there are 98 judges, 67 commissioners, 3,000 staff members, and the 2022 budget exceeded $310 million. That's a very robust and expensive enterprise.
Yeah, it is. And we're talking just the Maricopa County Superior Court, right, that does the civil and criminal cases here. We're not even talking about courts of appeals or justice courts and things. It's just in Maricopa County.
In Maricopa County. Obviously, that does not include the U.S. District Court judges and the commissioners there, or the magistrates rather. So you look at that and you think it should move faster. But you practice long enough, you get to know pretty much all the judges.
Yeah.
And to a person, they all say, we cannot handle the docket that we currently have.
Right.
Now, to be fair, those 98 judges are not all in civil.
Right.
So there's juvenile, criminal, family law, civil, there's the tax court. So there are not that many judges to handle the cases that we have. So number one, we have too many cases.
Sure.
And what do I attribute that to? First, to a litigious society, more litigious than we used to be. I think each generation says that, but it's true for
it's true.
The numbers bear it out.
Right.
I think it also, and I have nothing to back this up. I think it is also attributable to personal injury law firms advertising.
Yeah, there's a lot of them, right? And they advertise that you can get in, and
they're on everything but John's. I mean,
and maybe some of those is a great place,
right? So I think we have way too many cases.
Yeah,
and remember, in the civil docket in Maricopa County, if your lawsuit is alleging $50,000 or less than $50,000 in damages, you go to compulsory arbitration.
Right.
So that's not clogging up the courts.
Right.
Now, some of those cases, if they don't, they can appeal it.
Right.
But normally they don't. So there are too many lawsuits. In Maricopa County, we did go to a couple of years ago a specialized division. Right. Probably not a division, but specialized commercial court.
Yeah.
And so those are cases that generally exceed $300,000.
And they involve businesses.
Yes.
A business and a business.
Right. They're commercial court and they're more complex.
Right. Higher value, more complex. But there's only, what is there right now? 5 judges in commercial court? Maybe 4?
Yeah.
It doesn't provide much relief, right? No. Those judges are, I can imagine, I haven't seen their docket, but I can imagine hundreds of cases for each one of those judges.
Oh, yeah. Well, we have one of our cases that's in commercial court. I think we filed the complaint in February of 21, and we're still at the motion to dismiss stage.
Which is about as early in the case as you can get, right? For those of you who do or don't know, that's the lawsuit gets filed and you're in the motion to dismiss stage. So let's, there's some ways that Maricopa County, we've said, is trying to relieve this burden, sending cases to compulsory arbitration, right? They're creating the commercial division, but we have too many cases and the cases are all going on too long. As I have seen, there are some stages in the case that I think contribute to that. I'm sure every judge would tell you and every attorney would tell you they have cases or examples similar to the one you just mentioned. I can think of a few cases that were going on 18 months or more and we're nowhere near a trial date. Is there, in your mind, a particular stage of litigation that really bogs things down and that might be ripe for trying to speed this up? I hesitate to say it because we like discovery, we want as much information as we can get, but man, the discovery process takes forever sometimes.
It does, but if you go back a little bit, so you're meeting with the client, you draft the complaint, you file the complaint. Well, the complaint's supposed to be answered if it's an in-state defendant in 20 days.
Right.
Never happens. Everyone asks for a 30-day extension on top of the 20.
Right.
Okay. So that's a month out that you've just lost. Then what might happen, more times than not, rather than answering the complaint, they'll file a motion to dismiss the complaint. And the motion to dismiss is essentially saying that there's not a valid legal claim to be made. Right. And so the case shouldn't even be answered. It's that bad. Right. So that briefing schedule on a motion so you file a motion to dismiss, there's a response, there's a reply. Right. That's probably 60 days minimum. Right. Yeah, at least. So another 2 months. Right. Then you have to wait for the judge to rule. Well, the judge is not sitting at his or her desk waiting for your motion. They're busy. So it might be another couple months before a decision is reached. Right. Or longer.
Right. Yeah, I know we have cases sitting 100 days in front of judges waiting to be here. It's you've said a couple of times, right? Well, the answer is supposed to be in 20 days, but they're going to ask for 30. And I think it's important for folks to understand, it's sure, they're asking if we'll give them 30 days, but it's not really something that we can say no to in almost every circumstance, because if we say no, they're going to ask the court and the court's going to give them that time anyway, right? It just happens. It's the way it goes.
And just the way life is, at some point, you're going to need an extension on something. Right. So it's a professional courtesy. Right. And you definitely don't want the first thing in front of the judge is your refusal to grant them an extension.
Right. You being a jerk about an extension when they could say anything. And so, right, then we've got 20 days that you said turns into probably 50 or 60 just to answer or file the motion to dismiss. And then, it's supposed to be a response pretty quick thereafter, and we get that extended and the reply gets extended, and then the judge decides. So we could be, if someone files a motion to dismiss, 4 or 5 months on from filing the case and just getting to the point where the person has actually answered and we're starting discovery, right? And that's a huge problem. But as we're talking, I'm not sure I see a way around that.
Well, so there was a committee formed a while ago, comprised of people a lot smarter than I am, who came up with these revised rules of civil procedure. Okay. I don't think it's working. Yeah. But I don't have a better answer for it. That's the problem. One answer, which I don't think anybody wants, but would do it, is have firm deadlines. Yeah. In U.S. District Court, when you enter into a scheduling order, that's it. Yeah.
You're done.
Right. Unless you've been, transported to Mars, you're not going to get out of those dates.
That's right.
So that's one way to address it. But there have been other things that have been accomplished that actually have improved the system and have improved the speed of things. So, for example, this goes back probably 20 or more years. When I first started practicing, long before then, you could use impeachment evidence.
Yeah.
And so impeachment evidence did not have to be disclosed. We didn't have disclosure statements when I started. You didn't tell me anything. So you'd have this process where there was discovery and document production, expert witnesses all along, but hanging over here that no one knew about was this dagger that was going to destroy either the plaintiff's case or the defendant's defense.
Right. Yeah, right.
So you didn't know about it until you got to trial, and your witness is on the stand, and the lawyer doing the cross-examination says, "Madam Clerk, would you please pass the impeachment envelope?" And
very dramatic.
Oh, very dramatic. And people would put stuff in there wasn't anything, but it just scare the witness.
Right.
Yeah. But at times there was some very damning evidence in that impeachment envelope. So the Supreme Court, along with a committee, said, made the determination, as fun as that is, and as historical as it is, because it's been going on forever. Yeah. It's slowing down matters.
Right.
Matters would settle if you knew what that impeachment evidence was.
If this damning evidence was out there, it would have settled months ago.
Right.
That's the idea, right?
Right.
Okay.
You said the car was red. Well, that's not what you were driving. Here's a photograph.
Here's you in the blue car. What are you going to do?
Right.
Right. That surprises people when I talk to them about how we are required to turn over everything, clients and others alike, that, hey, when we start this, know that anything related to this claim or this defense is going to get turned over to the other side. It's going to probably make it in front of the court if we get there.
Yeah.
And it sounds like the point of that is to try to settle cases early. And I don't know what the statistics are in Maricopa County. You might, but I would say in my experience, 1% of cases we take actually end up in trial, though most of them toil around for a few years before they settle. So it seems to me that this goal of settling things before trial is working, just very, very slowly.
Yes, it is. And that impeachment rule really has, I think, resulted in cases getting settled quicker.
Yeah.
But not all of them, obviously.
Right.
When I first started practicing, there was no limit to the number of requests for production of documents you could send, interrogatories, requests for admissions. You get in a big case, like 1,000 requests for admissions. You go to the judge, say, this is unreasonable. The judge said, well, tell that to the Supreme Court. So that's no longer the case, obviously. There's a limit. You used to be able to depose a witness as long as you wanted.
Yeah.
Now in Maricopa County, it's 4 hours.
Right.
So there have been some tweaks to the system that I think have helped to expedite things. But again, I think it's just the sheer number of cases.
Right.
Because these different rule modifications that have occurred, I think they've worked, but there's just too many cases.
So I guess what we're saying is if our caseload now was what it was 30 years ago, we'd be moving through things very quickly.
I think so.
Because the caseload is so much more.
Yeah, I think so.
Right.
And you would think it would be so, considering how expensive it is to litigate. If you told a client that you're going to charge them $100,000 for this case, but it's going to get resolved in 3 months, we'll have a trial in 3 months, probably would be more palatable to them than saying it's going to cost you $1 million and we're going to get to trial in 3 years.
Right, maybe. Yeah, no, it's interesting to me that the juxtaposition. How do you allow people to have their day in court, allow them to seek justice, as we're saying, but you've got to move things efficiently so everybody can have that opportunity, so we're not bogged down. Now, there's also, I think, folks who aren't in the legal profession might not understand that you don't file the lawsuit and then get in front of the court on the trial. You're in front of the court a number of different times before
Right.
you're even thinking about trial, right? The motion to dismiss or a motion for summary judgment or a dispute about a discovery. And I think those things, while important, they also slow down the process because, I know recently we were trying to schedule things with the court and the court said, I don't have any time for 45 days. I can't get you in for an hour. So now we're 45 days out and everything's on hold. That also, I think, contributes all these little, I don't want to say little, they're not petty, they're not little things, they're big to that case and to that
Right.
litigant. But in the grand scheme of the courts, the 100 judges and 67 commissioners, they seem tiny and petty that they're having to deal with. I don't see a way around it. Again, apparently I don't see a lot of solutions here, but trying to talk about them.
Right. Well, it's like you're taking a huge amount of cases and you're throwing them into a funnel,
Mhm.
and the judge is at the end of the funnel.
Yeah.
So a lot of people think, without having been involved in legal matters,
Yeah.
that a judge is omniscient.
Yeah.
He knows everything.
Yep.
She knows everything.
Mhm.
Well, a judge is a lawyer by trade. Most of us lawyers and judges, all we've known is the law.
Right.
So we have coming at us, especially the judges, fact patterns of which they are not
Yeah.
familiar with.
Yeah.
It can be anything from a construction claim
Yeah.
to a reinsurance claim to a personal injury claim, medical malpractice. And we expect the judge to be able to just rule. Well,
Yeah.
that's not how it works.
Right. Know what's happening on all of these different things and know, how an architect was supposed to design this bridge and also how surgery was supposed
Right.
to happen.
Right.
It's a little crazy what we ask the judges.
Right. And the judges are government officials.
Yep.
Most government officials don't work overtime.
Right.
Judge, they work as hard as private lawyers.
Absolutely.
So, again, I keep going back to the fact that there are too many cases.
Yep. Is there a way? I know, a lot of times we try to, when we're helping clients draft agreements and things, especially in the construction world, we're looking at, hey, in your contract, maybe think about arbitration versus litigation as the dispute resolution forum. Is that a solution you see and something that could benefit the courts and litigants throughout the county?
If you'd asked me this 15 years ago, I would have said, yes, it's one way to, deal with the issue.
Right.
No.
Yeah.
What has happened, unfortunately, is arbitrations are taking just as long as trials. They're just as expensive as trials.
Yeah.
Especially in large matters. I don't know.
Yeah.
So if it's a small matter, then I would definitely consider arbitration because
Right.
you can at least have some control over with the arbitrator. Please, let's not make this we're the dispute's over $50,000.
Right.
Let's not make this, a dispute over $500,000.
Right. Let's not each spend $250,000 and get into the 50, right?
Right.
Yeah. Well, in the bigger cases, I think something I didn't realize initially, and it was just ignorance, but you're paying the arbitrator too most of the time, right? So you're adding expense if you're not keeping the timeline really tight.
Right. And it can be, depending on the contract, it could be a 3 arbitrator panel.
Yeah.
And so you'd have, the way those work, you have each party selects an independent arbitrator.
Yep.
I'll put independent in quotes.
Yeah.
Because you find somebody who is going to be on your side.
They're on your side.
Yeah. They don't know the facts, but their background. And,
right. Yeah. They've done cases like yours and sided with people like
right. If I'm a policyholder lawyer, I'm not going to hire the general counsel from CNA to be my party arbitrator.
Right. Right.
Okay. So those 2 party arbitrators then select an umpire.
Right.
So as a party to the arbitration, you pay the full cost of your party arbitrator and half the cost of the umpire.
Yeah. So
and they're charging
your
like
lawyer, your firm, and
right
$900 to these 2 guys.
Yeah, right. If you're paying out 3 times, right? Because you've got your own lawyer.
That's right. Yeah.
So smaller matters, I think arbitration will be fine.
Yeah. Okay. Well, I got us derailed. I want to sort of move us back to, we talked about some of the early motions, the discovery, the hearings. the trial time itself takes a long time. Just recently, I brought a proposed schedule to you, and I had written in, I think, 5 trial days. And I thought 5, that's a full week. We'll be in the court. It seems like a lot. And you said, yeah, I think we're going to need 10. I thought, wow, okay, we'll put in there 10 and we'll see what the other side has to say. But trial also takes a long time in court. And we've tried to streamline some of that with jury selection and doing that quicker, but it's still going to take a long time to get your case heard, right?
So the first day of trial, you select a jury if it's a jury trial. If it's a bench trial, you just start with your opening statement.
Right.
You're lucky if you get to one of the parties' opening statements on the first day.
Yeah.
So then you get the second day. Yep. Second day is going to be the other opening statement, and then you start with witnesses.
Yeah.
Now, what people don't understand until they see the process is that this judge who's presiding over your trial, this is not his only case or her only case.
Right.
They get called away a lot during trial.
Yeah.
They have to take recess to deal with somebody else's emergency.
Yep.
I don't know the caseload of the judges, but it wouldn't surprise me if some of them don't have 50 or more active cases.
Yeah. Yeah. But I would think at least that.
Yeah. And so they can't just be away from those other cases
for a week or 2 weeks or right. Can't go dark. Right?
No. So that takes away, adds more time to it as well.
Yeah.
So then inevitably there are arguments being made, objections that have to be heard. So it does take a long time.
Yeah. Yeah. It's not, and I don't mean to insinuate that it's time not well spent, right? It's necessary time and there are things happening. It just does take a lot of time. And then you get through a 2-week trial and the jury comes back, they give in a jury trial, they give a decision, it's in your favor. Well, then you're also maybe looking at, the other side has 30 days to decide to appeal. And if they appeal, that process can really drag out.
Right. And so I used to use as an example this show from the 80s called LA Law. But no one ever knows what I'm talking about anymore. So I'll use Suits as my example. You go into trial holding a 1-page document. That's not reality.
Yeah.
But what clients, I think, finally kind of get at some point is that in a trial, you're working almost from before the sun rises and after the sun
goes
sets.
down. Yeah. Definitely.
And so there's just a lot to do.
Yeah.
And you've got, just like the judge, the lawyer has other cases as well.
Right.
So it's a very hectic and intense time, regardless of what the issues are at trial. It's fun for the lawyers.
Yeah, of course.
But it's very stressful.
Right. It's stressful. It's time consuming. And like we've tried to, say in your mind, we're not the only game in town. The judge has a million things and the courthouse has, 10 judges or more, right? Doing everything that they need to and thousands of staff running around. So it strikes me as unfortunate, but I think Maricopa County at least is doing a lot to try to keep things moving. You mentioned to start that the technology here is pretty phenomenal, right? We're not having to go into court for hearings and things a lot. We can do depositions when possible, via Zoom and things that, maybe aren't our preferred way sometimes, but they're better for everybody. They're more efficient. But I think, it's important for somebody to remember if they're coming and they're planning on filing a lawsuit, it's going to be a couple of years before you get a resolution. And it could be longer than that, depending on the specifics of your case. And that's it's the unfortunate reality.
Right. The wheels of justice turn very slowly.
Right.
So I'm trying to think. We have a case that it's been pending since 2017. Now this one's not here. This is in New York.
Yeah.
But it's crazy, and there's no
end in sight. Right?
Doesn't seem to be.
Yeah, and that can be the way it goes sometimes.
Yeah. Now there's one blessing you can look at. There's a administrative proceeding here in the state of Arizona called the Gila River Water Adjudication. That's been pending for over 50 years.
Well, so look, my 2 years is nothing if
Right.
I'm looking at possibly being
Right.
at 50.
I'd like to calculate the total number of attorneys.
Attorney hours.
Well,
on that?
because it involves most of the tribes, involves a lot of ranchers and people claiming rights to the water, and
It's an important issue.
Yeah, very important
It's
issue,
going
yeah.
to be litigated, and the money's going to be spent on that.
right.
The state, I'm sure, is involved.
I assume so.
Wow. Well, that yeah, I don't know that I have too much more to say. It's just maddening at times, but I think we try to do our best to make sure things move quickly. Most of the opposing counsels we meet, I think, try to do the same thing. They're also busy, but we want to get things resolved, and it may get better and better. But I think, like you said, as long as people just keep wanting to be as litigious as they are, this is sort of the game that we have ourselves.
Yeah, in a sense, the legal market can dictate the number of cases, because as the hourly rate of firms continues to increase,
Yeah.
people are not going to take advantage of those legal services.
Right.
So that's by nature, you price yourself out of that market.
Right.
I think what's really important when you meet with a lawyer to talk about a potential lawsuit is to get them to be square with you on realistically what happens in this case.
Yeah.
How long is it going to take for us to get this either resolved or adjudicated?
Right.
And if the lawyer tells you they'll get to trial in 6 months, first of all, no way. Secondly, ask them, if you've listened to this podcast and you see the transcript, say, well, all right, you have to file a lawsuit. Are you going to give them an extension on answer to the complaint?
Right.
What if they file a motion to dismiss?
Yep.
What if they file a motion for summary judgment?
Or are you going to file one?
Yeah, right. What kind of experts do we have to have, if any?
Right.
What's that going to cost us?
Yeah.
Sometimes the experts can be not quite, but almost as expensive as the law firm.
Absolutely.
And importantly, am I going to recover any of my costs back?
Right.
I don't want to bring a claim for $100,000 if I'm going to incur $80,000 in legal fees,
Right.
$20,000 in expert costs, and I don't get anything for it.
Right.
Why have I gone through this?
Right. What was my point here, other than stressing myself out and wasting a couple of years of my life? Right.
Yes.
Yeah.
And it's like everything, but hopefully the lawyer you're meeting with will be upfront with you.
Yeah.
Be realistic. But it sometimes, depending on the law firm or the lawyer, if they're hot to go on something, they'll the one reason why they're a lawyer is that they're a good orator and somebody who can be persuasive.
Yeah, that's right.
And people typically put too much faith in our intelligence, the clients do.
Sure.
And so just be on guard.
Yeah.
Because what's the point?
Yeah. You want to do your best to try to see, are they telling you the truth? Are they giving it to you straight on costs, on how long it's going to take, and on how likely you are to be successful at whatever stage of the case?
Right. And on top of that, am I going to have to pay the other side's attorney's fees if we lose?
That's right. Yeah. Right. Like you just said, am I going to recover my costs? Well, if it goes poorly, am I looking at your bill plus their bill?
Yes.
And I'm really out of it. Yeah, that's a great point.
So I'm now in the negative.
Right. By quite a bit. Absolutely. Well, I it's good for people to know that this is what it is. It's good for people to get into litigation with their eyes wide open, make a really informed decision, because I don't want to sound like it's, hey, we discourage this, because there are sometimes when litigation is the only option. You can't get your justice, or you've been legitimately wronged and you have to sue. So it's necessary in a lot of cases, and I wouldn't want to insinuate otherwise.
Yeah, one additional thing I would add to the conversation with your prospective lawyer: how busy are you?
Yeah.
Do you have the time to take this on efficiently and timely?
Right.
Because if you don't, tell me now.
Yeah.
if you tell me you are able to do this, and I subsequently find out that you weren't,
Right.
then I'm not going to be very happy with you.
Yeah, absolutely. Right. You want to hire somebody who's ready to get jumping on discovery, and they make sure they're doing things to, at least from your end, either push the case to a settlement or move it towards trial efficiently, and not have to be the one. You said it earlier, we're all going to need an extension at some point or the other, but you don't want to hire somebody who is habitually asking for 30 and 60 and extra time and just delaying your justice. Your own lawyer's delaying your justice. It's not a good situation.
No.
Yep.
See that happen quite a bit.
Yeah, we certainly do. Well, I think it's been a good discussion today. I've enjoyed it. But thank you again for being here and letting me be here with you. And
Of course.
thank the audience for listening. Again, it's FR Law Group, frlawgroup.com. We'd certainly be pleased and honored to represent or discuss representation with any of you. We appreciate all of you listening, and we'll see you again in episode 9.
Thanks.